Be ready for the dictation. Start. The petitioners contend that the tribunal has committed an error by allowing the claim petition in view of the fact that the claim of the respondent number 2 had already been rejected, as he himself had voluntarily refused to take up the job of a sweeper, and therefore the respondent number 2 cannot claim compassionate appointment as a matter of right. Stop. It is further submitted that several reasons have been given while passing the order that the vacancies were not available within the 5% quota, and the appointment on compassionate ground is not a matter of right, and further respondent number 2 and his family was financially well off so as to provide enough aid, and hence compassionate appointment was not permissible in view of the guidelines framed by the government policy. Stop. Another reason given is that the claim is on account of death of respondent number 2, and therefore the compassion did not exist so as to give rise to any claim. Stop. Stanza. Shri I.P. Srivastav submits that the answering respondent was prepared even to perform the job of a sweeper, and the appointment of the answering respondent was cancelled by order dated 14th November 1998, which is bereft of any reasons. Stop. He further submits that so far as the consequent order dated 4th July 2002 is concerned, the same reflects non-application of mind inasmuch as it does not even refer to the earlier offer of compassionate appointment made by the respondents, and further none of the aforesaid contingencies are available for denying compassionate appointment as have been indicated therein. Stop. He further submits that the answering respondent is even now prepared to accept the job of a sweeper, and his claim survives inasmuch as he had approached the authority well within time. Stop. Stanza. Having heard learned counsel for the parties, it is evident that the claim for compassionate appointment was made immediately after the death of the father of the answering respondent. Stop. The said claim was processed and the appointment was offered to the respondent. Stop. It appears that another application had been moved by the answering respondent on 22nd May 1998, which was also pending consideration considering for being appointed as a Majdoor. Stop. The answering respondent appears to have made a request to the authorities that he would be unable to perform the job of a sweeper due to fear of a social boycott, and therefore he may be offered the job of a Majdoor. Stop. The cancellation order of 14th November 1998 appears to have been made only after such request had been made. Stop. The said cancellation order, coupled with the subsequent rejection on 4th July 2002, were challenged by means of an application before the tribunal, and the tribunal, after considering the submission raised, allowed the claim of the petitioner, quashing the aforesaid two orders, and the authority were directed to reconsider the applicant for appointment on a post of Majdoor, and in the interim period was also directed to allow the respondent to continue as Safai Wala. Stop. Para. The respondent preferred a writ petition before the High Court of Judicature at Bombay, which was ultimately allowed by the High Court by its judgment dated 27/7/2004. Stop. After briefly noticing the facts of the case, the High Court accepted the finding of the appellate bench that the appellant had not left the premises with the intention of staying with her brother permanently. Stop. The High Court also accepted the premises finding of fact recorded by the first appellate court that the appellant had no share in the flat in Ashoka Apartments and therefore had no right to stay therein. Stop. However, the High Court was impressed by the subsequent events which were brought to its notice by a civil application. Stop. The subsequent events which impressed the High Court were that the appellant's mother had died in the year 1976 and her sister-in-law had also died in the year 1982. Stop. Her brother was residing permanently in Goa to look after the ancestral family property. Stop. The learned judge held that apart from the appellant, all the others who were earlier residing with the appellant had either expired or had settled down elsewhere, and therefore the need of the other family members did not survive. Stop. The High Court concluded that her brother being a bachelor, the appellant has also inherited a share in his flat at Ashoka Apartments and thus became a co-owner, having a right to reside in the flat in Ashoka Apartments. Stop. Her brother no doubt was also a co-owner of the premises since he owned the premises jointly with her late brother. Stop. In view of the fact that she, as a co-owner, had a right to reside in the premises, her need of her own apartment did not survive. Stop. The High Court therefore concluded that in the changed circumstances and subsequent events which happened during the pendency of the writ petition before the High Court, the need of the appellant did not survive, and therefore the decree passed by the appellate court deserved to be set aside. Stop. Accordingly, the writ petition was allowed and the eviction petition was rejected. Stop. Stanza. Having noticed the evidence on record and the findings recorded by the courts below, we have come to the conclusion that this appeal must be allowed. Stop. The finding of bona fide personal need recorded by the appellate court is a finding of fact based on the evidence on record. Stop. We have considered the evidence on record and we find that the finding recorded by the appellate court did not deserve to be set aside. Stop. In fact, the High Court also was of the same view, but in the changed circumstances having regard to the events that took place during the pendency of the writ petition, the High Court interfered with the order of the appellate court. Stop. We hold that the High Court was not justified in doing so. Stop. It cannot be lost sight of that the premises which the appellant required for her personal bona fide need belonged to her. Stop. Stanza. Unfortunately, she suffered an accident, and in the absence of any other grown-up male member in the family, she was persuaded by her brother Lawrence to come and reside in his apartment, which was one of the flats in the Ashoka apartment and which was owned by him and his brother Tito. Stop. After residing there for several years, the appellant felt that she should not burden her brother anymore and therefore wanted to shift to her own accommodation, which was then in occupation of the respondent. Stop. The trial court made such of the fact that the appellant had also pleaded her bona fide need of providing accommodation to other members of the family. Stop. While doing so, the trial court completely lost sight of the fact that apart from the requirement of other members of the family, the appellant also required the premises for her own accommodation. Stop. Thus, even if the other members of the family no longer required the premises, the requirement of the appellant survived. Stop. She had every right to occupy her own premises and she could not be told that she should share accommodation with her brother in another apartment. Stop.